2024. We became involved. We met specifically, we being the DCI, met with legislative audit to include the legislature to obtain their assistance in the auditing. They began a request for a special audit report on February 27th, 2024. So this happened very rapidly. The process was stalled a little bit based upon record retention policies of both the state of South Dakota as well as a particular bank we were working with. So there were limitations of what the legislature and the legislative audit could do. The DCI was able to work through the records of various banks, personal records of the alleged defendant, as well as records within the Department of Social Services, again, with their cooperation. We've reached a point in the investigation where we were prepared, based upon our findings and our belief of what have occurred, to bring charges. An indictment was issued on Monday charging 2 counts of the state employee. Lana Carroll is her name. She's 68 years old. She was employed with the Department of Social Services up until March of 2023. Count 1 charges grand theft. It is a Class 2 felony, which carries a maximum penalty of 25 years. It is from the time frame of July 1, 2013 until the employee left March of 2023. The reason it's that time frame is because the law changed in 2013, July 1 of 2013. So count 2 deals with that law change. That particular count 2, is a Class 3 felony or a 15-year felony. Class 1 deals with theft of over $500,000. The law changed. Count 2 deals with theft of over $100,000. At this point, the defendant is presumed innocent under the United States Constitution. She has been arrested in Iowa. She has a $50,000 bond, and she's awaiting the extradition process. A little bit about the scheme and the nature of how this occurred. The $1.78 million is from Child Protection Services. Those dollars are primarily for foster care, but other child service related matters. When there is a need for those dollars, there is a request from the way that the process should work, there is a request from the employee for funds. That request should have a double supervisory review over it. Once it receives that double supervisory approval, it should go to the Department of Social Services financial side. It would then obtain that approval. Once it's obtained that approval, it would go over to the state auditor, where the state auditor would issue a warrant for payment, which is essentially a check. Depending upon the circumstances, it may also involve the state treasurer for either a wire transfer or relation to those funds to get to the right place. The scheme of what we believe happened, the information we found in the investigation, is the defendant was the employee making the request for assistance for a particular child. Once that request was made, she had also reached the position of being that supervisory approval. So she was the requesting person and the supervisory approval. It then went over to the Department of Social Services Financial. They then approved all the transactions. It then went to the state auditor that issued the warrant or the check, and then the defendant allegedly intercepted the funds, took it directly to the bank. Then when the check was deposited in the name of the bank in that particular bank, she immediately withdrew the funds, took the funds, the cash, to a different bank and placed them in her personal account. With respect to count 1, that would be approximately 399 transactions. With respect to count 2, that would be approximately 172 transactions. So again, at this point, the defendant is presumed innocent. We are involved in an extradition process out of Iowa. I would close by stating, as Attorney General, the citizens and taxpayers of South Dakota expect government agencies and employees to safeguard their dollars. And based upon my review and our investigation, we believe that has not occurred. And I have authorized and brought 2 felony criminal charges, and we're going through the process again. This defendant is presumed innocent, and I'll certainly make myself available to answer any questions that you have. Yes?
I'm not an auditor, but I've read a lot of audit reports over the years. That would seem ridiculous to me, that a person would have supervisory appeal over their own expenditures. Like, how did that happen?
You know, obviously, the Attorney General doesn't run that. I would tell you in my office, even myself has reviewed several different levels for a reimbursement. So all I can speak to is what I believe the process was designed and set up to be, and as we began reviewing things, what we found.
Have changes been made, implemented at this the department that you're aware of? I know it's not your department, but I mean, that's a pretty basic guardrail.
My understanding is those changes have been made, but again, the Attorney General's job, I mean, I would describe this much like other public corruption cases, like a bank robbery. Once the bank is robbed, I'm not in charge of whatever protections are put in place. I'm not in charge of security. I'm the guy that you call when things go bad, does an investigation, and then brings appropriate criminal charges, and that's what's occurred here. Yes?
Can you talk a little bit about the law change? And what did that entail?
Sure.
It sounds like consequences lessened after, I think you said 2013?
It depends on how you look at it. So hurdles became higher, consequences increased. So in 2013, the legislature and Governor Dugard did a review of, we called it Senate Bill 70. So Senate Bill 70 dealt with the adult side. Senate Bill 73 dealt with the juvenile side. You know, I've been an open critic of some parts of Senate Bill 70. So that law became into effect on July 1, 2013. The major changes are, so the reason count 2, it's the old law. Count 2 is a lower level felony. It's a class 3 felony, which is a 15-year felony, but it's a lower amount. So it's less consequences and less amount. We would only have to prove $100,000 or more. The law came into place. It increased the penalty, but it also increased what we have to prove for the amount. So in 2013, we don't have to prove $100,000 for this felony. We have to prove $500,000. And it went from a class 2 felony, or excuse me, a class 3 felony to a class 2 felony. So it went from a 15-year felony to a 25-year felony. So higher penalties, higher burdens for us on the proof side.
So who are the victims here? Taxpayers, families, kids who might receive benefits from Child Protective Services, all the above?
Yes. So I would generally, you're correct, I would generally describe it as this. It's approximately $1.78 million. Again, the proof is count 1 over $500,000, count 2, the proof is over $100,000. But beyond that, the allegations and the general nature and the scheme of this was, this is Child Protection Services. Child Protection Services receives federal and state funding for a lot of different important items. The majority of this would have generally been related to foster care. So there would be a child in foster care. They may need certain things, such as a bed, by example. The way it would work is that DSS employee would say, okay, this child needs a bed. They would begin the request process, that review that I talked about, the supervisors, the finances, the auditor. So those dollars may not directly have been taken from a particular child, but that is the $1.78 million is for Child Protection Services, either for a particular group of children or available for other kids. And so these dollars would have been specifically for children as a part of Child Protection Services.
So how much, like, per expenditure are we looking at? I mean, there's hundreds of instances. What's an average? Do you guys know this? Like, what's the average? Like $1,000, $10,000?
I can't get into specifics on evidence, but what I can say is with respect to, I can say the overall dollar amount is $1.78 million. With respect to count 1, it's 399 cash transactions. With respect to count 2, it's 172 transactions. They're all different amounts. There's really no average. It really depends upon what the request is. I can also say, generally speaking, as part of the overall scheme, it made it challenging to investigate it, and there'll be probably more said about it, but sometimes the source of the funds was adjusted by the defendant requesting the funds. So there's a program that you make the request in. Sometimes there would be a switch as to the source of those funds to make it a little bit more difficult to track, but we track those.
So these thefts allegedly occurred from 2010 to 2023?
Correct. January 1 of 2010 through March of 2023.
In your estimation, why do you think they went on for so long?
Again, my job is to come in when the bank is robbed and to address it, and that's what I've done.
Who is her boss? Who's the defendant's boss?
I can't get into specific employee issues.
Where was she in the hierarchy of this department?
She reached a level where she could request funds and self-approve funds.
Can you tell us her title?
Project assistant.
Who does the project assistant report to in the hierarchy?
That, you would have to ask the government agency in charge of that. I mean, the easy answer is if you were to ask somebody in my shop, who's the boss, that would be me.
So who was the department head during this period of time?
Well, it would have been from 2010 through 2023. There were more than one department head.
Do you suspect you'll be pressing more charges? Is there anyone else involved in this, or are you only just her right now? I mean, there's gotta be more people involved.
So, and you know this from working with me as a four-term attorney general, I mean, I keep that door open. In other words, I always want to view the evidence when my team comes to me with additional discoveries, witness matters. You know, I would indicate that, you know, I'll follow the evidence wherever it takes. I think it's appropriate to say that, as with any case, we would do an interview and then we would do an arrest, and we've treated this like any particular case. As things progress, that's possible, but at this point, generally speaking, under the scheme that I gave, there is no additional supervisor because she was serving as that supervisor. The question of whether or not it's good government or not and proper oversight, that's not criminal. Those are questions for the persons in charge of that agency in the South Dakota legislature. Again, I want to be very clear. This governor found out about it in February of 2024. This governor immediately contacted the Attorney General. We were trying to sort out whether it's 2 or 3 conversations directly with the governor on this. She's taken it very serious. She's been cooperative, and she's put up no roadblocks for me with respect to it, and I would include the Department of Social Services with that. They've assisted with us every step of the way, and so has legislative audit. I know that some legislators are informed. I would tell you that I personally called the head of appropriations to inform them of this investigation and what was occurring. And so they've been informed on it, but it will be up to them to make their own decisions on what they do with this. Again, my decision is limited as a criminal prosecutor to investigate it, make a determination of whether I believe there's probable cause that an offense has occurred. I believe there is. I brought the charges to a grand jury, and the grand jury concurred that there's probable cause and a reason to believe that a crime was committed and that it satisfies those 2 counts. Yes?
What are the documents called, like, that, you know, her name would be on these hundreds of times over this period?
So there's a couple of different documents. There would be initially, and again, it's not appropriate for a prosecutor to comment and place weight on evidence because I need to be fair. These are allegations only, and she's presumed innocent. But generally speaking, I can talk about it because it's taxpayer dollars in that process. So the way that process worked, and it's a public record, there would be an initial request. So in the system, in the DS system, there'd be a request for certain funding. I use the bed as an example, just because one of those happened and it sticks in my mind. That request has a document with it. That then goes to supervisors that have documents with it. That then goes within the DSS to the financial side, and that has documents and approval with it. It then goes to the auditor, which has additional documents, and then the auditor issues that warrant. We call it a warrant, but really it's a check. And that check was made out to a particular bank. Because of their request information, it's tied to a particular child, and that's how we're able to track it. But there would be a check with a bank's name on it. She then would take the check to the bank, and then she would either sign it or initial it. And then the bank would make a payment, and then we go to a different bank and we can find a deposit slip in a particular account. Those would be generally the paperwork that you would look to.
Did she have more than one personal account?
I can't get into those specifics.
Can you describe described the nature of her leaving. That was in March of 2023, basically a year before this was discovered in February of this year. Did she retire? Was she terminated?
Because she did not work for my office, I can tell you what my understanding is. My understanding is she retired.
Okay.
And just to be clear, for clarity's sake, she was arrested in Iowa on these charges?
Correct. And she's on a $50,000 bond, and as with any case in another state, there's an extradition process, and we are going through that process now. I would tell you that,
Was she residing in Iowa? Was she
Yes.
residing in Iowa?
that's my understanding.
What city was she arrested in?
Algona?
Where was she based during this time? Pierce, Sioux Falls?
Primarily Pier. I mean, we're at a big time frame. I mean, we're January 2010 through March 2023, but Pier.
Most of it's in.
Yes,
Was it ever somewhere else? Did she work in other places or?
primarily Pier. I mean, from a regional supervisor standpoint on the approvals, it's Pier.
Can you speak any more to what actually led to this getting caught, basically a year after she was?
I have to be very general again. I can talk about the nature of the investigation, the scheme. Department of Social Services detected financial irregularities through part of a system check and some improvements that were already being made. And when that was then alerted to the Department of Social Services, it came to the governor's attention, who immediately contacted me in our office.
Is the governor gonna release a statement on this? Do you know?
You know, I should not speak for the governor, so what I would say is this: I just want to be very clear that she immediately notified us. I've had specific conversations with her, and she has been completely cooperative.
Is there anybody from social services here, or are we all law enforcement?
We're all law enforcement.
Okay.
Do you have any indication of how the 1.8 million spent at all? How she used it?
Yes, I'm not sure it would be appropriate for me to, I mean, let me generally state, if we were to do an investigation, one of the things we look for is motive. I understand you can have financial motive, but motive is an appropriate thing that a jury is instructed on, that you can look for. So we would look to motive. So we would have looked at spending habits. We generally look for if there's an addiction, whether it be gaming or other related. And what I can state is at this time is my understanding is there will not be a strong likelihood of recovery for restitution.
So, gambling.
No, I did not say that.
Okay.
I just said that there will not likely be a recovery, a significant recovery for restitution. In other words, as part of the arrest, no assets were seized.
Is this, I mean, it's a big event here today, is this the largest or one of the largest fraud cases? Put this in perspective, I mean, money's money, right? 1.8 million, a lot of money, but is it the biggest you know?
You know, certainly I've prosecuted EB5, I've prosecuted Gear Up. This is on the same level on size. This time frame is probably a little longer. You know, in South Dakota, we have a discovery statute. That's what triggers the statute of limitations. Because this wasn't discovered until February of 2024, it gives me certain ability to go, you know, back differently than I perhaps have been able to in other instances. But that's why, as you're looking at this and you're wondering, well, don't we have statute of limitations in South Dakota? How is he going back to January of 2010? Because it's a discovery statute.
Are you, you said your understanding is that changes have been made, but as a law enforcement agent, are you comfortable with the changes that have been made? I mean, is there any discussion back and forth between you and DSS about further safeguards on the people's money?
That's not my place. My place is to come in when the safeguards have not been safeguards and to address criminal conduct or alleged criminal conduct, and that's the position I've taken in EB5, that's the position I've taken in Gear Up, and that's the position I've taken here. The Attorney General doesn't run those offices. It's not my place to tell anybody how to run those offices. It's my place, if a crime has been committed, if taxpayer dollars have been stolen, to address that. And that's what's occurring here with respect to an indictment being issued and arrest being made.
So this ultimately is the governor's responsibility to talk about whatever changes have been made, because it's unlikely that anybody in social services is going to talk about that. So it's a political question in some measure, but who's going to answer that question? Governor?
You'd have to ask those questions. I mean, again, what I would state is this governor immediately upon finding out took action. I mean, the week they discovered it, the governor notified the Attorney General. The governor and DSS's team sat down with DCI. DCI sat down with legislative audit, and the special report audit was requested and moving forward. That was all done within a week.
So this spans 3 governors if we're going all the way back to 2010, correct? That's the original,
January of 2010.
okay, so we're talking 3 governors this occurred under.
Yes.
So how often does the governor come across this paperwork? I mean, was it just because of a system check, or do we need to be doing these checks more often? I guess is what I'm asking.
You know, again, my job as Attorney General is when the bank is robbed to address it.
But how does law prevent this from happening in the future?
You know, those are questions for the legislature. Obviously, the legislature is involved in this investigation, and they'll be, you know, looking into this and making their own determinations on what laws need to be put in place. I can see there may be a look at retention policies. I mean, you've heard me indicate that I've been able to move forward and say it's 1.78, but as special reports are issued from legislative audit, you'll see that there were various retention policies that made it challenging on their end with respect to the audit, and we had to go to other places to piece that together. I envision that those will all be looked at, and again, my understanding is the governor was putting additional things in place, which was how these irregularities were discovered, and we were immediately notified. And I can't stress that enough. Again, this is not an instance where they find something and they're wondering when Jack Lee's going to find out about it and what he's going to do. They immediately came to us and we acted.
Are you confident then that, are you looking at, is there going to be any sort of comprehensive audit? Would that be you? I mean, if there's this one point of criminality in this one person, but it would seem that it's a systemic issue over a period of time, are there other people that should be looked at, not in relation to this person, but under the whole system that was operating for all those years?
You know, what I would say is that's really what legislative audit does. I mean, the legislature is in charge of, through appropriations, taxpayer dollars. Legislative audit is that arm of the legislature to audit and review kind of before the fact. This instance, it's a little bit of after the fact, but that's what the auditors do. And so that would be their place, not the Attorney General's place. Again, my job is to enforce the laws when they're broken, and that's exactly what we've done here.
I know your answer to this question, but there's been a lot of discussion over the years about the auditor's office in particular. all right?
Especially when the Auditor General's name was Marty and my name is Marty, that created some confusion over the years.
Do we have strong enough audit? This is just one department, one person. For many years, there's been discussion about how the government's spending is monitored. Is this an example of a failure of our government to properly manage the people's money?
That's not my place at this stage to answer that. I mean, my place is, again, when the bank is robbed, to address the bank robbers. It's not my job to go into a bank and say, hey, you might want additional security, you might want to review your protocols. It's my job within the Attorney General's office to do that. But it's not my job in other state government, nor my place. And so I'm sticking in my lane, and my lane is as a criminal investigator working with the DCI and the Attorney General as a prosecutor to say, this is what we're going to do. I would point out too, though, I described to you the scheme. I don't know that an audit, additional audits, would have necessarily discovered a situation of theft where you have an employee sliding themselves into a dual supervisory position. That may or may not have come up if signatures would have been noticed, etc. I'm just pointing that out. This scheme was a situation where what you generally had going on is a employee making a request, positioning themselves to also be that level of supervisory approval, intercepting checks, going to separate banks, switching at some levels sources of those funds and resources. So the question is whether or not that would have been identified in either protocol reviews or an audit, and again, that is not my place. My place is to say, we looked at it, this is what we believe happened, and based upon that, we moved forward with criminal charges, and the defendant is presumed innocent, and the case will proceed like any other case, beginning with an extradition process.
With Miss Carroll, is there any thought that she had any personal or family ties to anyone who received a paycheck from South Dakota state government, or had any tie to anyone in a position of influence?
You know, certainly those are questions that you would look at in an investigation. That's a fair question and a good question, but I can't comment beyond the nature and scheme of what occurred under the rules, you know, specifically the rules of ethics.
Marty, you make recommendations on changes in law all the time. Attorney General brings bills. Is this something that your office is going to look at and make a recommendation of changes in law, given what you've learned?
Normally, that's a very fair question. I mean, normally the changes in law would be with respect to what hurdles the legislature puts in place for us. You know, I talked about the old law, what's 100,000, now it's 500,000. What the appropriate penalties are, again, and I talked about maximum penalties. I mean, the penalty she's facing under count 1 is 0 to 25. Count 2, it's 0 to 15. Those would likely be my recommendations. When it comes to audits, that's really the legislature and the governor's office that would determine those type of protocols and checks. I'm certainly would be involved in those conversations. It's not uncommon for the legislature to call the Attorney General in. I believe it happened with both EB-5 and Gear Up, and to generally, again, like I'm doing here, describe what we did in an investigation, what we generally found, but then I'm not asked the next question, what do we need to put in place? I'm the guy that just simply says, this is what we found, and it's their job to determine what changes are appropriate and are necessary. Again, the last thing you need from the Attorney General is somebody that's judge, jury, and executioner. I mean, there's a role of the Attorney General, and that role here is an investigator and a prosecutor.
My memory is not as sharp, maybe as it once was, on bills. SB 70, which one? I remember the number. I remember what was it, what was that bill, and why were you critical of it? I don't remember.
Senate Bill 70 was the adult one. Senate Bill 73 was the juvenile one. It would have been in the 2012 legislative session. You may recall I was the last person to sign off on it. I had asked for several things, some of which we received, some of which we did not. Some of the positive parts of Senate Bill 70 is that's how we now have SAVIN. So victims are now able to find out information about their case. That's important. That's a good thing. It was put under the Attorney General, and I think it runs fairly well. There's challenges with it. There were other pieces of it, for instance, under this particular case. But for Senate Bill 70, this would be a 15-year felony. I'm able to now talk about how we brought a 25-year felony. So there's some positive aspects of it. One of the aspects that you've heard me be critical of, and from day one, was presumptive probation. Recently, we handled a case involving a very serious threat to the governor and a very serious threat to a judge. At the time of sentencing, Senate Bill 70 was used against us, and that person received presumptive probation. That was in early July. Fast forward, the President of the United States is shot. And again, I think it signifies, well, you have to act on these things. These are threats of violence. They're serious. And that's just an example of where I think Senate Bill 70 could be improved, is to look at how we deal with presumptive probation. I'm not suggesting we necessarily completely get rid of it. We should look at the offenses. We should look at cooperation, particularly in the drug world. If a defendant is not cooperating with us and telling us where the distributors are at, I'm not sure they should receive presumptive probation. We have a methamphetamine and a fentanyl problem. I think the statements that I've always made regarding presumptive probation have been proven, and I hope and encourage the legislature to work with us. Those conversations are occurring, particularly after the sentence of the threat to a judge and the governor, and I think the legislature will take a good look at it, and that's all I can ask as Attorney General. But those are some of the examples of what Senate Bill 70 was. It took a look at our criminal justice system, made some good changes, and made some changes that maybe law enforcement wasn't completely comfortable with, and that we are continually trying to work through and improve.
Any other questions?
It's my understanding that the indictment is sealed right now and may be unsealed this afternoon. Is that correct? And can you explain why that might be sealed?
The answer is yes, the indictment was initially sealed. Typically, what we will do is we will want to make sure we put in place certain protections for a defendant. Sometimes it's better that a defendant, not learn of the charges publicly, because they might take some action to harm themselves or others, or they can make it more difficult to make an arrest. And so we do certain things carefully so that we have every interest in, the defendant is presumed innocent. We don't want to have anything happen with that. We don't want to create potential dangers for law enforcement. And this is just general in nature. So typically these type of items are sealed until proceedings reach a certain point. This one, I believe it states until the arrest was made. The arrest has now been made, working with the clerk's office to have it available. Typically, we like to have the clerk provide it, but we also know they have busy jobs, and if the clerk would prefer we do it, we certainly are willing to do that. But at this point, I would direct you to the clerk's office to be able to obtain some of the arrest-related documents, including the grand jury indictment.
That's in Minnehaha County?
Hughes County.
Hughes County, okay.
Tony, you're gonna send it out.
When we get it, we'll send it out.
Upon approval of the clerk.
Yep.
Again, I don't want to create more work for the clerk that's very busy, but I also don't want to step on the clerk's toes.
Any other questions?
Thank you, everyone.
Call if you need me. If you got questions, give me a call. Thank you.